Good afternoon, everyone. Welcome to Division 1 of the Colorado Court of Appeals. My name is Craig Welling. To my left is Judge Daniel Taubman, and to my right, Judge Stephen Bernard. And we are Division 1 of the Colorado Court of Appeals. And we have one case on our docket for argument this afternoon, People v. Lancaster, 2016 CA 1165. Have counsel had an opportunity to review our procedures? Any questions? Okay. So each side will have 15 minutes for argument. You'll be responsible for managing your own time. If the appellant would like some assistance, let me know, and I'll do my best to assist you in reserving time. Just a reminder that today's proceedings are being live streamed over the internet as well as archived on our website. So to the extent that there is any sensitive information that you do not want out there in that form, please tailor your argument accordingly. And finally, what I would ask is that everybody please turn off any pagers or cell phones that you might have. Merely putting them on silent still interferes with our recording equipment. So we would appreciate that. With that said, are we ready to begin? All right.
Good afternoon. My name's Leslie Goldstein, attorney registration number 24658. I am representing Mr. Lancaster. I would start by letting the court know that I plan to proceed on the first issue. I believe it is dispositive of the second issue. In this case, Mr. Lancaster went to trial. He was convicted. He was ultimately sentenced on October 1st, 2007. The facts regarding his unequivocal decision or request to appeal his conviction is established by the record, and I don't believe that there's really any dispute about that. The trial lawyer testified at the Rule 35C hearing and agreed that Mr. Lancaster made it very clear that he wanted to directly appeal his conviction. What is also equally clear is that there was a fee agreement in place. The trial counsel had been privately retained, and contained within the fee agreement, it specifically stated that upon sentencing, representation would conclude. So I am not here to debate those particular facts. I would say to the court, however, though, that the fee agreement is not dispositive upon the issues. I think it's very clear under Rule 44D, as well as People v. Baker and People v. Long, that trial counsel has an unequivocal duty to perfect an appeal for a client.
Did you rely on 44D below at the 35C proceeding? Certainly the impression that the post-conviction trial judge, district court judge had was that this was not, your argument did not rely on 44D.
I don't believe that the trial counsel specifically referenced 44D, but I believe that he essentially made arguments encompassing the substance of 44D.
So the spirit of 44D
yes,
was there?
Yes.
Is that enough? I mean, because really this does rise and fall on the 44D analysis from Baker, right?
I believe so, but not, in addition to 44D, I guess I would say, is that we also have People v. Long and People v. Baker. And what those two cases talk about, which also cites to the U.S. Supreme Court, Roe v. Flores-Ortega, is that a trial counsel's representation does not just end at sentencing. So even if we do not cite to the particular rule of 44D, we still know that a trial counsel's representation does not end at sentencing hearing. And what 44D says, though, is that it ends upon when a Rule 35B motion has been filed and or ruled upon, and or a notice of appeal has been filed by the defendant. In 2007, I believe the timeline for filing a 35B was 120 days. At the time of 2007, the time to file a notice of appeal was 45 days. So certainly the time for filing a notice of appeal was within the 120 days. So even though trial counsel believed that he had a fee agreement that specifically said that his representation ends at sentencing hearing, that is not what the rule says, regardless of whether a trial attorney post-conviction counsel cited to it or not. It doesn't change things that representation does not end until either 120 days when a 35B has been filed and or subsequent to that, if it had been filed and not ruled upon, or when the defendant had filed a notice of appeal. So here it's clear that a notice of appeal had not been filed in this case, that trial counsel was adamant that he was not going to file a notice of appeal.
Ms. Goldstein, I'd like
yes.
to ask you to explain your understanding of the relationship between CRIMP 44E 3 and 4. 4 is the subsection you were just referring to about filing the notice of appeal, but subsection 3 says after a sentence is imposed upon conviction when no motion has been filed pursuant to 35B or such motion filed is ruled on. So why wouldn't subsection 3 apply here?
If I'm understanding the court correctly, 3 says, though, a 35B has been filed upon and or subsequently ruled on, which would get you past the 120 days. So
No, it says after a sentence, it says the trial court proceedings shall conclude at the point in time, and then it says in subsection 3, after a sentence to incarceration is imposed upon conviction when no motion has been filed under Rule 35B. So here, there was a sentence imposed after conviction, and there was no 35B motion. So why didn't the representation end the day sentence was imposed pursuant to the fee agreement and that subsection 3?
okay, well, my position is, Your Honor, is that under 35B, you still have 120 days from the date that you were sentenced to file a Rule 35B motion. And so I don't think you can make that sentencing or the representation of trial counsel does not end at the sentencing hearing, because under 35B, you still have 120 days to file that. So up until the 120th day, trial counsel is still representing Mr. Lancaster. If it doesn't get filed, the 35B motion doesn't get filed on day 121, then representation would have concluded at that point. So what I'm saying to the court is that under Rule 44D, a notice of appeal had to have been filed within 45 days. That 45 days certainly is within the 120 days. I noticed that the state did.
Pardon me for interrupting, Ms. Goldstein, if I may, please. I want to take you in a little bit different direction. Based upon the document from defense counsel saying when his representation ended. Like most things, defendant could waive. Let's assume 44D applies, and let's assume 44D works in the way that you say it does. Then defendant could waive that, couldn't he?
So I do not agree that a fee agreement would waive, a defendant would waive his rights under 44D.
Are you saying that your client had not read the fee agreement or had not signed it or was not privy to it?
So no, I'm not making those arguments. Those arguments have, I would suggest that a fee agreement, regardless of whether an individual enters into a fee agreement knowingly, you cannot waive certain rights that are given through the rules, through Rule 44D.
Why not?
Well, I would, I guess, show the court to People v. Baker, where the court said that the trial lawyer in Baker was under the mistaken belief that his representation ended, again, at sentencing hearing. But as a favor to his client, he decided that he would go ahead and file the notice of appeal, and then unfortunately, he filed it in the wrong court, and Mr. Baker was deprived of his direct appellate rights.
But in Baker, pardon me for interrupting again, but in Baker, isn't Baker distinguishable? Because in Baker, there hadn't been this clear agreement between client and lawyer. This is when my representation ends. Baker was very clear about that there had not been such an agreement. The lawyer may have been mistaken about that, but there was no written agreement in Baker.
But I think the way we look at Baker is that the court in Baker said that's really not the definitive issue. The definitive issue is that actually, in fact, under 44D, representation goes beyond the date of sentencing. And I would suggest to the court it goes to at least 120 days post-sentencing hearing, which is the time frame to file a 35B in 2007. So even though the specifics of whether or not there was a fee agreement in People v. Baker, the court looked at this more broadly and said, regardless of what the parties believed, under the rule, representation goes beyond the date of sentencing.
And counsel, don't you have some textual support for the notion of what work a fee agreement can do? Because the introductory clause to E1 says, unless otherwise directed by the trial court or extended by an agreement, not if modified by an agreement, but extended. Doesn't the rule only provide that an agreement can extend the duration of representation, not reduce it by unilateral, by agreement between counsel and the client?
I guess I would disagree, and I believe that Mr. Lancaster made it absolutely clear that he wanted this to go and be appealed. What I think is also significant is that this was unequivocally conveyed to trial counsel, and the trial counsel took absolutely no steps and just said, well, the public defender's pretty good with appeals, I trust them, but he did not give defendant any, let alone any tools to actually perfect the appeal on his own. And certainly, I, again, would argue that under 44D, that the representation went beyond the actual sentencing date.
One other question I have, and I just, because it was a fact that was present in Baker, and it's also a fact that's present here that wasn't highlighted as best I could tell by anybody. Does it matter that the trial court did not advise the defendant am I correct that the trial court did not advise the defendant at sentencing of his right to appeal and his right to court-appointed counsel on appeal?
I believe that is correct. I did not argue that particular point in my briefs, but I also believe that under the rules, the court is required to advise Mr. Lancaster of his right to appeal and the right to have court-appointed counsel on appeal. So I guess I would look at this as that there were several failures, not only by trial counsel, but also by the trial court, which served to deprive Mr. Lancaster of the proceedings in and of itself.
What do we do with the fact that that's not been argued?
I'm sorry?
What do we do with the fact that that has not been argued or raised until right now?
You know, Judge, I can't answer that.
Okay. All right.
Thank
That's fair
you.
enough. Fair enough.
I would ask the court to reinstate Mr. Lancaster's direct appeal rights. Thank you.
Thank you very much, Ms. Goldstein. Ms. Brackett.
May it please the court, Brenna Brackett, attorney registration number 43003 for the people. So shortly after the jury found defendant guilty in this case, he asked defense counsel, what kind of appeals do we do? That's the one question he asked, and that one question was not enough to establish sufficient performance or prejudice in this case, especially here, where after he had a few months to think about things, he got up at sentencing and admitted, I took advantage of him being the minor victim of sexual assault in this case. And I'm willing to take any type of therapy as necessary to never repeat this terrible act ever again as long as I live. He said the court had given him a fair trial. He thanked defense counsel for helping him out with the case. The one simple question he asked months earlier doesn't show that he was provided ineffective assistance in this case.
There's not a dispute that he had communicated to Mr. Newell that he wished to pursue a direct appeal, right?
He expressed a desire to have direct appeal. When it came down to putting on the evidence at the hearing, that was what was said. His expression of a desire to do an appeal was months earlier, months before sentencing, before an appeal would have been filed, him asking about what they would do, what sort of appeal they would do. So I don't agree that it's such an unequivocal, specific instruction in this case as in other cases. There was, I agree though, that, like you said, they both did testify at the 35C hearing that at some point he had expressed a desire to file a direct appeal.
Ms. Brackett, I'd like to ask you a question about Crim P 44E2. I don't know if that was cited in the briefs, but it says at the time of a deferred prosecution or deferred sentence is granted, or at the time sentence is imposed upon conviction, the court shall inform the defendant when representation shall terminate. Do you know if, number one, do you think that applies here? And number two, do you know if there's anything in the record that indicates that the trial court advised Mr. Lancaster as to when his, Mr. Newell's representation would terminate?
I think E2 is not at issue in this case. It doesn't apply in this case because E2 is about, I think, a deferred prosecution or sentence. So I don't think that.
No, the first part of it refers to a deferred prosecution or sentence, but then the next phrase says, or at the time sentence is imposed upon conviction, which is the circumstance we have here. Then it says, the court shall inform the defendant when representation shall terminate.
Right, and so I think as I read that section, and I could be wrong, I didn't focus on that section, because I think that even upon conviction, I think that it's all referring to the deferred circumstance in this case, just by way of the.
How do you read?
Because of the way the numbers are laid out, so it's E1. E1 talks about
I think
generally
he's at
E2.
Arabic 2, not Roman 2. E1 has subparts Roman 1, Roman 2, Roman 3. Then there is subpart 2, which is, I think, what Judge Taubman is reading from.
Yes.
I'm sorry. I thought we were in a different subsection.
I had a hunch, so.
Yeah, no, thank you
E1
for
too.
clarifying the
Okay.
difference between Roman and Arabic numbers.
Yes. So when an order enters granting a deferred prosecution, deferred sentence, or probation, or sub 3 after a sentence to incarceration imposed. Is that where we are?
Right.
No,
No.
no, the very last sentence of Rule 44 is subsection E, Arabic number 2.
Okay, right, and
And it doesn't say anything about probation. It just says, at the time of deferred prosecution or deferred sentence, or at the time sentence is imposed upon conviction. That's what I was referring to, a sentence imposed upon conviction, which I believe is the circumstance we have here. And then it says, the court shall inform the defendant when representation shall terminate. So again, I was asking, does this sentence apply to the case here? And if it does, is there anything in the record that indicates that the trial court advised Mr. Lancaster when Mr. Newell's representation would terminate?
Okay, so I'm at the right, I know where we are on the rule. My position is this doesn't apply in this case. As I read the rule, because we do have the Arabic 1 and Arabic 2, I believe this case falls under Arabic 1 because that's the one that talks about, that also talks about imposing a sentence. So it talks about an order to probation,
Well,
an order, a sentence to
subsection
incarceration.
1, excuse me for interrupting. Subsection 1 deals with when trial court proceedings shall conclude. Subsection 2 is, as I
The
understand it.
advisement, this is what we're asking. Sorry.
Excuse me?
I think I understand your question now. Sorry, I didn't mean to interrupt. You're asking about the advisement from the trial court.
Right, subsection 2 deals with an advisement. It doesn't deal with when the representation terminates. It addresses a court's obligation to advise the defendant about when the termination has concluded or will conclude.
It's okay. So is there an obligation for the trial court to do that? Yes. Did the trial court do that in this case? No. Does that decide the question of ineffective assistance of counsel? No. So I want to take a step back, because I think the Supreme Court has even said that in the federal rules, there might be an obligation for the trial court to do that. There is an obligation for the trial court to do that. The trial court should do that. That doesn't mean that there's ineffective assistance of counsel. Those are two different questions. And that's not the question that we have in this case. So I believe that did apply, and the trial court didn't do it, but I don't think it decides anything in this case.
Does it matter that this is postured as an ineffective assistance of counsel claim as opposed to had Mr. Lancaster just gone ahead and filed his appeal out of time and tried to basically, after getting a show cause order from this court, responds under Baker?
It does, and I agree that I think Baker is a different case than this case. So I want to start with, because I think we'll talk about Crim P44 and Baker. This is an ineffective assistance of counsel case. We're not here to talk about what would have been perfect representation, what would have been best.
Let me ask
Okay.
my hypothetical differently. Had Mr. Lancaster, under the facts of this case, just filed his direct appeal instead of filing a 35C when he did, would he have been able to pursue that appeal under the facts that are present in Lancaster and under the decision in Baker? Would this court have had any discretion to basically say, I'm sorry, we're without jurisdiction, appeal rejected?
Yes, I think they would have.
How?
So I think it's what makes this case different from Baker. So the things that are the same about this case in Baker is that they both agreed with their attorney that representation was going to end at sentencing, right? And they were both convicted, obviously. But that's where the similarities end between this and Baker. So in Baker, the defendant indicated at sentencing he was interested in having a public defender appointed for appeal. That didn't happen in this case. He actually prepared a handwritten notice of appeal. The defendant didn't in this case. He showed it to him, and then defense counsel said, how about I file that for you?
But the court in Baker seemed to really say that yes, that's a very interesting fact that there was almost this detrimental reliance, but that's not what they focused on and said that's kind of a red herring. What's really the problem is the way that 44E operates, and he was still representing him and had an obligation to do it and do it right, regardless of the agreement.
And that's where the procedural posture does make a difference in this case. I agree. So because what we are looking at here is not whether or not the rule was followed, and the ineffective assistance of counsel looks at the constitutional obligation of counsel. So what rights you actually have under the Constitution, not under the rules. And the Constitution does not incorporate every rule of criminal procedure. And I think the Supreme Court in Roe v. Flores-Ortega actually addressed this issue. They're considering when counsel has an obligation to consult with the defendant about an appeal. And they say, it would be better practice to routinely consult with defendant about his right to appeal. Definitely be better practice. And the state can impose a per se duty, and did in that case in California, had a per se duty for trial counsel to consult with the defendant about the possibility of an appeal. But the Supreme Court said, while states are free to impose whatever specific rules they see fit to ensure that criminal defendants are well represented, we have held that the federal Constitution imposes one general requirement, that counsel make objectively reasonable choices. So Crim P44 doesn't govern in this case. There's one question that has to be answered, whether they made objectively reasonable choices. And in that case, in Flores-Ortega, despite the fact that that state rule requiring it, they were not able to say as a constitutional matter that in every case the failure to consult is necessarily unreasonable. So it's not necessarily ineffective.
I understand. This isn't really necessarily about violating, maybe cast this differently. It's not necessarily about violating the rule, but your contention, as I understood it, is there can't be ineffective assistance of counsel because he wasn't counsel anymore, and he communicated that. And so he wasn't his lawyer. So how can you be ineffective when you don't have an attorney-client relationship anymore, right? Is that part of your argument?
It's part of it, yes.
Okay. So the work the rule is doing here is not imposing a constitutional duty to file the appeal. It is defining whether or not he was still his lawyer. And 44D says, sorry, you were still his lawyer at the time. Therefore, now we determine whether or not failing to perfect an appeal for a client that you knew wanted to appeal was constitutionally deficient. That doesn't write on the rule.
I think it does in some respects because you're saying based on the rule, you're his attorney, but we are not looking at whether under that state rule, what that obligation is. We're looking at under the Constitution, what was objectively reasonable conduct based on the facts of this case. And in this case, the defendant was not relying on Crim P44. There is absolutely no indication that he had ever read that rule or was relying on it. He did not believe that he was in a relationship with that attorney anymore. He didn't think that was the case. So he didn't rely on the attorney, because that's what the Supreme Court talks about. The reason that it's ineffective assistance, that it's deficient performance, let me stick with that wrong, is to not file an appeal when there has been specific instructions is because that a defendant is reasonably relying upon counsel to file the necessary notice. Defendant here was not relying on counsel to file that notice. There was absolutely no reliance on this. He did not expect him to file a notice. He agreed that representation had ended, regardless of the rule.
But what if it hadn't?
What if
representation hadn't ended? Regardless of what they agreed on or what they thought, he was still his lawyer. Doesn't that impact the analysis?
As to under the state rules, and I guess I'm just saying, I think my position is that he wasn't his client because he wasn't, and that the Constitution doesn't look at the state rules. But I think there's another way that they can be affirmed in this case, which is also that aside from deficient performance, he also has to show prejudice. And
Before we get to that,
Oh.
Ms. Brackett, I'd like to ask you about the waiver question that I asked Ms. Goldstein. Can you waive the application of the rule? And if so, did that happen in this case?
again, I think you can waive it in terms of my constitutional rights. It's not required on the Constitution. So yes, you can waive it for purposes of the constitutional analysis. Because I think part of what the rule is there for is not just the protection of the defendant. This isn't all about protecting the defendant. It's also about protecting the court proceedings, because we don't like it when the day of trial arrives and they say, defense counsel says, he hasn't paid me, so I'm not going to trial. And then the court has the choice to say in that case, oh no, you are going to trial. Everybody's here and we're ready to go. And it would be a problem for justice as a whole if we were to let you not continue representation in this case. So that's part of the purpose of the rule. It's not just about protecting the defendant. And so in terms of the representation he has, yes, I think it can be waived.
But doesn't the rule provide two mechanisms here? One is the work an agreement can do is to extend and only extend. It doesn't say modified by agreement, just extended by an agreement, right? Mm-hmm. Or if you want to terminate earlier, you can get leave of the court. So if they wanted to terminate at sentencing, court could have granted that, could have made that request, right? But where in the rule textually is the basis for just the defendant and his client to make this agreement without the blessing of the court and have it be effective?
It's effective in terms of the Constitution. That's my point, is that I don't think it's effective. What should counsel have done? He should have filed a notice to withdraw. I don't disagree with you on that. But in terms of whether or not that was ineffective for constitutional purposes, that's where the difference is. That's what he should have done. That's better practice. But the Constitution doesn't require you to be a perfect attorney. It doesn't require you to be the best attorney. It's what's objectively reasonable. And he had an agreement with his client. His client understood he was not representing him at that point, regardless of what the rule said. He advised the client, the
Ms.
defendant.
Brackett, what does the Constitution require regarding the right of a defendant in a criminal case to file an appeal?
What does the Constitution require? So in terms of Flores-Ortega, we know that if there's specific instruction to file that appeal to your attorney, he has to file that appeal generally. Beyond that, it's a consultation. Not even a consultation, only a consultation when it's objectively reasonable. And that's really what Supreme Court focused on, is that we need to look at every case individually. We look at the very specific facts of every case and determine whether or not what happened was objectively reasonable. And that's it. There are very few per se duties. The Supreme Court has eschewed per se duties. And my time is about to expire. If no further questions, I would just ask the court to affirm the order denying post-conviction relief in this case.
Very good. Thank you, Ms. Brackett. Ms. Goldstein, you have 2 minutes and 52 seconds.
Judge Bernard, I would like to address the issue as to whether or not the fee agreement waived
Please
Rule
do.
44D. I would say that a waiver has to be made knowingly and voluntarily and intelligently. And I have not read, granted, the fee agreement in a long time, but I do not believe it explicitly stated in the fee agreement under Rule 44D, my representation remains until the time for a 35B has expired or such motion has been ruled on or a notice of appeal has been filed. But under this fee agreement, I'm asking you to waive that right. So I don't believe that was explicitly stated in the fee agreement. I would also disagree with the state and their reliance on People Lopez, citing to the two-prong analysis under Strickland. Under People v. Long, it discusses that a deprivation of direct appeal rights is a different kind of claim of ineffective assistance of counsel. And when someone is deprived of their direct appeal rights, the prejudice is presumed. And that's under People v. Long, 126 P. 3rd 286. So again, I would ask the court to find that the trial court error denying relief was in error and to reinstate my client's direct appeal rights. Thank you.
Thank you, counsel. Thank you to counsel for both parties. These arguments, as well as your briefs, have been very, very helpful. The case will stand as submitted, and a written opinion will issue in due course. This also ends our 1:30 our docket for today, so we will be in recess, subject to call if the bailiff will so announce.
Thank you so much. It was nice to meet you.